Case number 116398, State of Kansas v. Tyler Riegelman.
May it please the court, Tony Cruz on behalf of the state of Kansas, the appellant. I would like to reserve 5 minutes for rebuttal.
5 minutes is granted.
This case started back on December 22nd of 2015, where members of the Junction City Police Department were asked to conduct what's commonly referred to as a welfare check of Tyler Riegelman. Mr. Riegelman had not been to work for a few days, and the officers went to his residence to try to make contact to make sure that he was okay. Officer Kathy of the Junction City Police Department stepped up onto the porch of the defendant's residence, could smell the odor of what he believed to be raw marijuana, knocked on the door. He was accompanied by, I believe it was a trainee. Mr. Riegelman opened up the door. Once the door opened, the officer testified actually on at least 2 occasions that he smelled a strong odor of raw marijuana coming out of the residence. Mr. Riegelman stepped out of the residence. He inquired if he was okay. Mr. Riegelman advised he was. Then Officer Kathy asked him about the odor of raw marijuana, and Mr. Riegelman at first denied that there was any odor, and then started to make some statements about how he wanted to leave, and he was prevented from leaving due to the odor of raw marijuana.
It was more than statements. He says, "I don't smoke and I'm going to leave." He turned around and started walking away.
Correct.
And he was stopped.
Correct.
Specifically, stopped Mr. Riegelman
Right.
and brought back up on the porch.
Right.
And eventually handcuffed.
Right. During that time period,
So what's the reason he can't leave his own residence?
because
I mean, you're not there under any suspicion of a crime being committed. So what's the reason he just can't walk off the porch and go?
Because by the time he is actually detained, there is actually evidence of a crime. That is the odor of raw marijuana coming out of his residence. And that is reasonable suspicion to conduct what's commonly referred to as a Terry stop, to temporarily detain him while the search warrant that is applied for and while the search warrant is executed. There is U.S. Supreme Court case law, I believe there's a Summers case that authorizes law enforcement officers to detain people at the site of a search warrant saying pending the execution of that search warrant, and that's why he was detained.
There was no warrant here.
At that time, there was not, because the officer had not applied for it. However, this would
He hadn't even announced he was going to apply for it by then, was he?
Yes, he did.
He had before he started to walk away?
Yes.
Okay.
And that is why.
That's significantly different on the facts, because once you've had a detached neutral magistrate make the determination that there's probable cause to believe a crime has been committed and that there's fruits or evidence of that crime within that house, it's different than the investigatory circumstance we have.
I don't think so, because this would be no different than if a police officer were to stop a car for traffic
The
violation.
main difference is they stop the car because they have a reasonable suspicion of a crime, and we allow the questioning that goes along with that stop. This was a welfare contact.
And if
They were there on a public welfare stop.
they were. And once he smelled the odor of raw marijuana, that immediately transferred this to a criminal case. And at that point, the officer had reasonable suspicion to detain him because the officer had probable cause to believe there was drugs, specifically marijuana, within that residence.
You were sitting here during the last case too, and in both cases they've the odor specifically referred to, and you only referred to it as raw marijuana. Is there a reason that it's distinguished for law enforcement purposes? Are they trained to make the distinction? Does it have any difference in the application for a search warrant, or make any difference for the search or the subsequent search What's the distinction, and why is it distinguished?
Okay. Officers are trained to distinguish between the odor of burnt marijuana and raw marijuana. Not in this context for search warrant. However, they are trained to do so during a traffic stop, because the scope of the search during a traffic stop is dependent on what the officer smells. For example, if he smells the odor of raw marijuana and the vehicle happens to have a trunk, case law is quite clear, the officer is not allowed to search the trunk. The officer is allowed to search the passenger compartment only. If the officer searches the passenger compartment...
We have cases that make that distinction?
Yes, sir. And that's why once they search that compartment or that passenger compartment, if they find contraband, once they find contraband, they're allowed to search the entire vehicle. And I think I just may have misquoted myself. If they smell
said it
burnt
backwards.
marijuana...
You said it backwards, yeah.
burnt is,
Okay,
you gotta
burnt
stay
marijuana
in
is just
passenger.
the passenger area.
I think these are Court of Appeals cases rather than ours, right?
I believe so.
Yeah.
Now,
and-
was there evidence in the record of this training?
No. No.
So these officers didn't testify as to any training that they had?
This particular officer testified that he had trained in the odor of at least raw marijuana, and I know there was testimony during the suppression hearing that he had smelled the odor of raw marijuana approximately 50 times prior to this incident.
Is
And
there
did
any
he explain
testimony? Excuse me. Go ahead.
Did he explain exactly what training it is? How are they trained, or what happens with this training?
No, just that I believe that was done through the Kansas Law Enforcement Training Center.
So nothing about the amount of raw marijuana it takes to make the odor detectable?
No, because that'll be basically done a case by case.
Well, I mean, when they train them, they must use a certain amount in order to train them what it smells like.
Right.
And
No,
there's
no,
no
no,
testimony
no,
in this
no,
record to
no.
tell us how much it takes to smell it.
No. So
Or the distance from which you can smell it,
that is correct.
or the amount of time that the odor remains. If you have marijuana in your front room and a guest has it and they leave and the odor lingers for a couple of days, is that still probable cause to believe that you're going to have evidence of the crime? Doesn't there have to be some kind of more nexus between this place and the suspicion?
Judge, I don't think so, simply because the case law on canines, I think, is probably on point here, that the case law is pretty clear, that if you get a positive that indication or alert by a drug canine, that's sufficient probable cause. And there's no way for a drug canine to be able to advise the officer the length of the odor being in there. So I think that has the same premise here, where the officer can smell the odor of raw marijuana. And again, it's only to a probable cause standard, not that there will be drugs there, but there's a fair probability there's going to be drugs there.
And so once he forms, his training gives him probable cause to believe there's marijuana, and he intends to take this person into custody, or at least restrain their movement. We've been talking about the Fourth Amendment. Let's talk about the Fifth Amendment. We have all the cases that say that if you're going to interrogate someone who is in custody, and in custody means a person who does not feel free to leave and disengage from the questioning, that you have to give the Miranda warnings. And here the Miranda warnings were not given until after the search.
I believe that is correct.
And he was on the porch, denied the ability to leave. He tried to leave, and so a reasonable person in his position would believe he wasn't free to leave when he tried to leave, and the officer came after him, stopped him, and took him back to the porch. Wouldn't you agree a reasonable person would not feel free to leave and disengage?
I would agree that at that point he was detained. I don't believe he was in custody pursuant to Miranda, which is required. There is a pretty big difference between being detained for investigative purposes and being detained through custody for interrogation purposes. And in this particular case, he was detained, and the statements he made were all
He was being detained. They asked to go in the house. He said no. So
correct.
he was being detained while they got a search warrant.
Correct.
And
And
the
statements-
investigation, their investigation of him had basically ended. They were seeking a warrant to gather evidence. So it's not like the traffic stop where you're trying to gain the information so you can write tickets and that kind of thing. It had gone beyond that.
No, Judge, because the investigation was just starting. Because the officer had just smelled the odor of raw marijuana. The officer could have gotten it, and did, kept in a search warrant. If he had
Okay, he
searched the
denied,
residence,
he denied that there was a smell of marijuana, said he doesn't smoke. The officer asked, I want to look inside your house. He said no. He said, okay, we're going to wait for a search warrant. And then the defendant tried to leave and was detained and brought back on the porch and eventually handcuffed. And you're saying that he was not in custody, was allowed to be incriminate himself at that point freely. The officer could get him to incriminate himself freely at that point.
no, the officer detained him. And between the time he was detained to the time the officer actually put the handcuffs on, Mr. Riegelman made a lot of statements about how he had a problem.
If the defendant was in fact in custody, do you lose? In other words, if we disagree with the argument you're making right now, do you lose? Or do you have an alternative way that you think you still prevail?
Well, given the fact that the officer was not asking him questions, these statements were voluntarily made. They were spontaneous statements. Nobody was asking him questions. So even if he was in custody,
So, how can you say that? He says, I've got a problem. The officer says, what is your problem?
Yeah, they are asking
Hurting,
questions.
how are you hurting yourself?
Right.
He said, I'm only hurting myself, and then the officer follows up.
and that statement could be going back to the original reason why the officer was there, and that is a public safety, or I'm sorry, a child welfare. How is he hurting himself? Is he suicidal? Is he homicidal? Is he does he suffer from suppression, or I'm sorry, depression?
None of that matters if it's a custodial interrogation, though, does it?
The question was if he was incriminating himself. I mean, all the officer was doing was trying to figure out, how are you trying to hurt yourself? How do you mean that? Clarification. Again, not trying to get
Let's go
him
back-
to incriminate himself.
Let's go back to my colleague's question. If we don't agree with you,
Mhm.
and we find that he was in custody for Fifth Amendment purposes, the officer was required to give Miranda warnings before he interrogated, or the functional equivalent of interrogation, and failed to do so, resulting in impermissible, a suppressible confession. What's the outcome in this case?
That would mean that his statements would be suppressed.
And then the statements would not have been available for the warrant.
In
And
that
so
case-
how does that, we're trying to get to the point, does that flaw then knock down the House of Cards?
No, because if that were the case, then all that the court would need to do is to excise those statements and say, besides his incriminating statements, is there still enough probable cause for a magistrate to issue the search warrant?
And
As-
what do you, I'm sorry, go ahead.
No, we need to reassess it, or do we look at, would the magistrate have looked at the totality of the circumstances, and when you take a confession out, we can't be certain that the magistrate would have reached the same conclusion?
I believe this court has the ability to excise those statements and look at the surviving affidavit and determine whether or not the information within the original affidavit minus the statements that the court finds are not admissible, and determine if there was probable cause.
Refresh my recollection, what does that leave you besides the officer saying we smelled marijuana?
That's pretty much it.
And what's your argument that's enough?
I believe what the Court of Appeals in upholding the district court is going down a very dangerous path here, and that is it is creating a different standard of probable cause for residents. So there is this odor plus standard, which is starting to create this sliding scale of probable cause. You have probable cause based on the odor of marijuana per car that basically, due to the exigent circumstances of the mobility of the car, negates the need for a warrant. For a house, I think the probable cause standard happens to be the exact same, the odor of marijuana. The only difference is that you have to obtain a search warrant. And I think that the case law is pretty clear on that. But what the Court of Appeals is doing is saying, well, you have to have odor plus. Well, then that's going to create a whole bunch of different questions about, well, what is that plus? And where does everything else fall in between? Because now you have different standards of probable cause. Because you're going to have a different standard of probable cause for a person, because it's at a house. You're going to have a different, potentially a different standard of probable cause for a hotel room, because it's not quite a residence, but it's not a car, so it falls in between. So what exactly is it? So
We've
there's
already got a sliding scale. We've already got a sliding scale. You can't, if you have probable cause, you can't go in the house and search. The only way you get to search a car is because we say the mobility of the car provides exigent circumstances. So we already have a bifurcated system when it comes to the expectation of privacy and the ability to search a house versus a vehicle or other place.
I don't think that is a sliding scale. I think that's just, there's a different legal requirement, as in you have to obtain a search warrant. Probable cause is probable cause. There is no sliding scale on that, because otherwise, because again, there'd be this whole system of, well, this is probable cause for this, but it's not probable cause for this. The odor of marijuana is probable cause to search a car. The only difference is you don't need a warrant. And all the state's arguing here is that the odor of marijuana is probable cause to search a house. You just have to obtain a search warrant, and that's the protections provided by the Fourth Amendment. Also, the U.S. Supreme Court in Kentucky versus King had almost the exact same type of argument, and that is that they had the odor of marijuana coming out of one or two apartments. Officers couldn't figure out which one, knocked on one, heard scuffling. Oh, I'm sorry. This started out as a drug deal. And one of the drug dealers went into one of two apartments. Officers, there was an apartment on the right-hand side, apartment on the left-hand side. Officers could smell the odor of burnt marijuana coming out of the apartment on the left, knocked on the door, announced their presence, heard scuffling around, and the U.S. Supreme Court said that the officers, based on the odor, had probable cause and exigent circumstances because of the scuffling around.
Well, that a little bit, there were a little bit more there. The police were, they were following a suspect, and they followed that suspect into the apartment, heard the door shut, knew that he went into one of two, and so there was plus there. There was odor plus.
Well, the only thing is that on that particular case, one thing is that the officers didn't know which apartment he had gone into. So based on that, if the officers had applied for a search warrant just on the fact that we've got a 50-50 chance here of picking the right one, no judge could have signed that warrant. So there was no probable cause based on the drug dealer. This was based solely on
But they weren't
the
doing
odor.
a public safety stop. They were following the suspect, and they already had a suspicion that he was committing a crime. It was
Right,
a little
right.
bit more than we have here.
Okay.
I wanted to go back to your statement about probable cause is probable cause. My notes reflect you've told us that if officers have probable cause to search a vehicle, they can proceed without a warrant.
Yes, sir.
Okay. If you had the same level of probable cause, because you said probable cause is probable cause, if you want to search the residence, you have to go to the magistrate to get the search warrant.
Correct.
So if probable cause is probable cause, and that is when you have the strong smell of marijuana, is there ever going to be a magistrate who says, I'm not going to issue this warrant? In other words, what's the value of having the neutral and detached magistrate if we're telling them in all circumstances, strong smell of marijuana means you're going to be able to search without a warrant if you're the police officer, with the warrant from the magistrate? So what's the difference?
I think we already have that standard now, because that we tell officers, if you've got the odor of marijuana coming out of a car, you don't even have to go to a judge. You can just search it, and that's pretty much a bright line rule. And I know that the court doesn't like them, but we already have those already. And to me, this is just the exact same thing. A lot of the cases I cite, and I know that this court in the Huff case cited several cases outside of our jurisdiction, saying that for a search warrant for residence, it requires odor plus. In U.S. v. Kerr, which is cited in Huff, the Ninth Circuit said there by far the most incriminating evidence was the odor of marijuana. Now, in that case, granted, they had odor plus, and one of
Raw
the
marijuana or burnt?
I want to say that was burnt marijuana.
I think
because there was an informant.
At least it seems to me that there's got to be some distinction because, you know, the Johnson case upon which you rely, the U.S. Supreme Court, talked about the affiant being qualified to know the owner and that it's sufficiently distinctive to identify the forbidden substance. I think it's be tough to challenge the distinctiveness of burnt marijuana, but I'm not so sure about raw marijuana.
Of all the officers I've ever had testify about the odors of raw marijuana and its distinctfulness, every single one of them have said each has its own distinct odor. And
Has any of
nothing
them
smells like
ever
raw marijuana.
testified to any of those things we were asking you about earlier?
Ma'am?
Has any one of those officers that you've heard testify about the distinction between the raw and the burnt odor ever also testified about the training that they received in any detail whatsoever?
It's been based on field experience.
Right. Vague, I'm an experienced officer, I had training, but not, it takes this much raw marijuana to smell it, not, it lingers this long.
No.
None of that.
No. And one of the other cases that, and I think this was a critical case, one of the cases cited in Huff is an Arizona case called State versus Caldwell. It's a 1973 case. One of the cases I cite in my supplemental brief is State versus Cisco. That's a 2017 case out of Arizona. And the reason why I think that's an important case here is because the state of Arizona has decriminalized marijuana to a certain extent and permits medical use marijuana. The Arizona Supreme Court held that the odor of raw marijuana is sufficient probable cause to issue a search warrant. Now, granted, it was for a warehouse, but I think that the premise is still here. Once you establish probable cause is a probable cause. And I think it's extremely pertinent here, where if you have a state where marijuana is legalized to a certain extent, and their own Supreme Court says it's still sufficient, the odor alone is still sufficient to obtain a search warrant, here in Kansas, where we don't permit any sort of marijuana whatsoever, I think it's pretty critical. And in the other cases I cited, there are certain jurisdictions, a lot of other jurisdictions that permit search warrants based solely on the odor. And again, the only thing the state's trying to do here is keep one single standard of probable cause. And I understand that a lot of the cases have the odor and something else. I don't think that those cases should be read as saying they need that something else. I think that they're just saying based on the totality of the circumstances, the odor and everything else, probable cause here is pretty evident. And so I'd ask his court to deny, or I'm sorry, to reverse the Court of Appeals and the District Court.
Do you have any questions? Thank you,
Thank you.
counsel.
May it please the court, Amber Cabrera of the North Central Regional Public Defender's Office appearing on behalf of Tyler Riegelman. Mr. Riegelman is also present here today. This court has functionally adopted an odor plus standard because it has refused to hold that the odor of marijuana emanating from a vehicle is sufficient probable cause to justify searching a person who is located inside of that vehicle. Instead, this court has continued to re-emphasize that it is a totality of the circumstance analysis that is necessary in order to reach a finding of probable cause. At the core of the Fourth Amendment in Section 15 of the Kansas Constitution stands the right for a person to be able to retreat into their home and be free from unreasonable governmental intrusion. When we're dealing with our home, where our privacy expectations are the most heightened, it is unreasonable to find that the odor of raw marijuana alone is sufficient probable cause to search the home, because it leaves only one factor for a magistrate to consider in what is supposed to be a totality of the circumstance analysis.
But isn't the totality of the circumstances that you're dealing with in the passenger car not so much just a focus on what is the source of the smell, in that you can't tell if it's the driver or the passenger? Similarly with the apartments and some of those situations we've dealt with, you can't tell if it's coming from apartment A or apartment B. But with the totality of the circumstances in this case, where you have a home, you're standing on the porch, it's don't those totality of the circumstances lean towards a reliance on odor?
No, Your Honor, because the search warrant is important not because of the document itself, but what the role that the neutral magistrate plays. They are required to provide a balanced assessment of the weight of the evidence that is in a search warrant affidavit. When you just have what the state is requesting, probable cause equals probable cause, that eliminates the role of the neutral magistrate.
I didn't understand the state to be suggesting that we would do away with the warrant requirement.
No, but it would be the functional equivalent of taking away the role of the magistrate, so the search warrant in and of itself is meaningless, because the magistrate is really why the search warrant is important.
Wouldn't the magistrate still be weighing the totality of the circumstances to determine whether or not it was credible or that enough to establish probable cause under the circumstances of that case that you were smelling an odor?
No, Your Honor, because it is only one factor for a magistrate to consider, and it is essentially a person is unable to refute that one allegation. In this case, the officer claimed that before Mr. Riegelman even exited the home, that he could smell an ounce of marijuana that was inside of a bag, inside of a wooden box that was several feet from the front door. There's no way to challenge that the officer was ever misleading to the court. In cases where we're dealing with confidential informants, where we're dealing with anonymous tips, where officers have to provide additional information about the confidential informant's veracity, reliability, or cooperation to support the anonymous tips, in the event that an officer is misleading to the court, those facts can be independently verified, and they can be presented to a magistrate through a Franks hearing. Essentially, with the odor alone standard that the state is requesting the court to uphold, that would render absolute discretion for officers to be able to enter into anybody's home on that allegation alone. And when you're giving absolute discretion to officers, what that does is that provides an avenue for officers to be able to abuse and enter into people's homes.
Because the officers might be lying. Is that your
Yes,
argument?
and again, if the law recognizes that a home has the highest expectation of privacy, where a person should be free from unreasonable governmental intrusion, and we provide an avenue for officers to...
But why do we need to go to the policy arguments and deterrence kind of thing, it seems to me that if we make a bright line rule that plain smell is always probable cause, that we basically take away the function of the magistrate, and that if in fact there are different circumstances, you might have had a visitor that had 12 pounds of marijuana in your front room and had just left. I mean, there's different scenarios. There could be a 50-mile-an-hour wind while the officer's standing on the front porch. The magistrate should be able to take into account everything. But to say that we require more from a magistrate that finds it very credible, to me is just as bad as saying we're going to require the magistrate to say the smell is probable cause. That's why we have a magistrate and search warrants. They get to look at the whole thing. And so I don't think we can make a bright line rule one way or another and maintain the independence and neutrality and purpose of a search warrant.
Well, Your Honor, I think the odor plus standard protects the role of the magistrate, because an officer, when they just allege, I smell the odor of raw marijuana, that is only one circumstance, so a magistrate judge cannot weigh any evidence, because that would functionally be it. And
You're
again,
saying, are you arguing that totality of the circumstances requires, I mean, you're calling them elements, I'll use that language too, more than one element, if you will?
Yeah.
I guess I'm struggling with what is the plus that you're arguing for? Because there's always a plus, isn't there?
well, in this case, with just odor alone, which is what would have resulted.
But is that really, I mean, I know we've talked about that, odor alone, but in the real world, that seems to me to be an abstraction that is not real.
Well, Your Honor,
It's never offered in isolation. There's always a plus, even if it's just, I was standing on the porch. I mean, that's a plus.
Well, Your Honor, I think that to support that there is the crime of possession of marijuana, standing on a porch isn't an additional circumstance.
What if you're standing on the porch and you see marijuana through the open door?
I think that would be something to support the odor of marijuana.
No, there's no odor. I just say I was standing on the porch and I saw what in my training appeared to be marijuana.
And Your Honor, I think
that's one factor. I mean, so would you argue that that's not sufficient?
Because of the ability to refute it. If an officer, for example, if they peer into my apartment window and see my herb garden and yet think it's a grow operation, I can at the very least obtain a photograph, demonstrate it to a magistrate that, look, this officer either one is not trained to properly identify a marijuana plant, or two, that he misled the court in saying that he believed that there was a marijuana plant or marijuana in the house. The problem with just odor is that it's so subjective and there's no way to refute whether or not an officer is misleading the court. And what you're doing there is giving them absolute discretion to be able to enter into anybody's home.
You're just saying it sounds to me like your primary argument is this kind of evidence is simply not reliable enough.
Yes, Your Honor. And I would note as well that the record, in full candor to the court, the record does have questioning of the officer as to the distinction between raw and burnt marijuana. The officer could only state that raw marijuana was fresh and vegetative and burnt marijuana smelled burnt. So I think that also is indicative of the fact that this is just not reliable enough to allow officers to be able to intrude into our homes, where we have already said this is a sacred space, and give it the highest expectation of privacy. And ultimately, the search warrant is the only thing that's left, or in the search warrant, the only thing that's left is the odor of marijuana. Mr. Riegelman was unlawfully arrested at the point that he was told he couldn't leave his home. At that time, the officer did not have probable cause to search Mr. Riegelman's home. The officer didn't let Mr. Riegelman go back inside of his home. He subsequently placed him in handcuffs. He interrogated him.
But he made incriminating statements before he was handcuffed.
Yes, he was
And so how do you address opposing counsel's argument that we have allowed preliminary questioning during an investigatory detention, and how this is different?
Because he was in custody. It was clear he was not free to go because he had made the attempt.
But if you're stopped by on the highway, you're not free to leave. If you get in your car and try to leave, you're going to be stopped. You're not free to leave at that point. But we have case law that says, well, you're not really in custody. It's just an investigatory detention. And how do we distinguish this circumstance before he's handcuffed? I don't have too much problem once you handcuff someone. But before he's in handcuff, he was just told to stand on the porch. We're going to wait for a search warrant.
In the traffic stop context, you naturally assume once you get the ticket, you're going to be able to go. That's why in those situations, it is not considered a custodial interrogation in the event that there are travel plan questions or whatnot. In this case, the officer didn't have a search warrant. He didn't have probable cause to search. Mr. Riegelman made the actual attempt to leave, and he was told he couldn't. He couldn't go back inside his home. At that point, and prior to the questioning, the officer made clear to Mr. Riegelman as well, I am investigating the odor of marijuana. And then it was questioning as a result of one statement that was not the statement that was put into the search warrant affidavit, but a paraphrased statement elicited from the back and forth questioning that was put into the search warrant affidavit. After he was interrogated, he was placed in handcuffs. They conducted a pat-down search. He then heard he had to provide typical information that is taken upon arrest, such as his date of birth, his weight. He heard the officer request a criminal history check. He then was taken to sit inside of the patrol vehicle and watch a multitude of officers arrive, and he was in those circumstances for over an hour. And there is nothing on the record that would indicate that Mr. Riegelman, in fact, posed any danger to the officer or posed any flight risk. He followed every single direction that the officer asked him to do, and he also, at one point, put his hands on top of his head, a clear sign of submission. Because the officer never afforded Mr. Riegelman his Miranda rights prior to questioning him, and because they were attempts to elicit incriminating information in support of his investigation of the odor of marijuana, as well as the unlawful arrest, the statements were properly excised, and the exclusionary rule is also applicable, and the good faith exception doesn't apply in this situation. Any reasonableness that this officer would have had in believing that the search warrant was valid was derived from his own actions in violating Mr. Riegelman's Fourth and Fifth Amendment rights.
Well, that's what the good faith exception, at least in part, is intended to do, is allow an officer to act in reliance on a neutral detached magistrate. So why isn't that what happened here?
Because the actions that were the good faith exception doesn't function to excuse constitutional violations. It only excuses whether or not there was sufficient probable cause. The problem here is that all of the actions that the officer did that went towards the probable cause, well, not all of them, but the statements that went towards the probable cause determination were a result of the violations that occurred against Mr. Riegelman's constitutional rights. And the exclusionary rule is applicable because, again, any reasonableness he would have had was derived from his own violation.
Are you saying the officer knew of things that should have let him know that there were violations, but the magistrate didn't know those facts? In other words, the affidavit didn't include recitations of the facts that would establish a Fifth Amendment violation or whatever?
As to, yes, Your Honor, I think that there were additional facts that would have been relevant as to the unlawful arrest and about the interrogation that weren't in the search warrant affidavit. And again, the purpose of the exclusionary rule in this case is met because the violations that occurred in this instance, if the exclusionary rule weren't to be applied in this instance, what it would allow officers to do is to continuously violate a person's Fourth and Fifth Amendment rights, put stuff in a search warrant, and rely on that good faith exception. And that's not what the good faith exception is for. It does not function to erase unlawful conduct by the officer. It just functions to in the event that the probable cause determination because of a magistrate isn't met, that the officer's okay. But this is
case,
distinct.
what the magistrate had was an affidavit that I smelled marijuana. The defendant confessed that, yeah, I do marijuana, and yes, I have it. It's by the couch. So it wasn't real tough for the magistrate to find probable cause with all that information.
Yes, Your Honor, I'd agree. I'm out of time. If I could have a bit of time, Your Honor, to provide a concluding statement.
I'll give you 30 seconds, counsel.
Okay. Your Honor, I would just ask that this court affirm both the appellate and district court's rulings. Thank you.
Do we have any more questions? All right, thank you, counsel.
And I'll wrap this up.
Counsel, I'm just going to jump right in and follow up on that. Was the magistrate aware of the circumstances surrounding the statements by the defendant that were put into the affidavit?
The search warrant affidavit was part of the record, and I believe it's advised that he was Mirandized and made statements.
No, I don't think so.
I don't think
I don't
there was
think
any
you're right.
statements about him being in handcuffs.
No.
If that's
Or that he was
wasn't.
Mirandized?
He wasn't Mirandized until after the search,
Oh,
so it didn't
sorry.
advise of that.
No.
So that just to follow up then is how do you respond to defense counsel's argument that, look, the good faith exception can't apply here because the officers had knowledge that the magistrate didn't have, and that knowledge of facts that are really important.
Well, the problem is that defense counsel didn't make that argument at the district court level. The only argument at the district court level was that the search warrant lacked probable cause due to the odor. Not that, and they could have requested some sort of Frank's hearing saying that the officer deliberately omitted certain facts. That was never done.
When did the state claim the good faith exception applied?
From the very beginning. When they filed their suppression, we filed a response, and we claimed from the beginning that good faith that applied because at the time their motion to suppress only dealt with the lack of probable cause in the search warrant affidavit based on the odor. And so the state responded that the officers had good faith to rely on the odor being the basis of his search warrant affidavit. One of the cases, and is basically the main case that the defense relies on, and that's State v. Huff. Well, if this court recalls, Huff involved a case where an officer said they smelled the odor of burnt marijuana, but couldn't tell if it came off of a person who just came out of an apartment or the actual apartment. So this case, or this court held that based on that, it wasn't sure if any court could have issued a search warrant for the apartment because there was no nexus to the apartment. The officers couldn't testify where the odor came from. This is not what we have here. Here we have an officer who's on the door, on the defendant's porch, right by the door, could smell the odor. He knocks on the door opens up, he now smells the strong odor of raw marijuana.
Do you agree that with your opposing counsel about the amount that was ultimately found and the condition in which it was found? It was an ounce or so in a baggie in a box 30 feet from the door.
I can't recall how it was found.
How much was it?
I don't recall. Sorry.
That's right.
But
Would you agree at some point, the credibility of plain smell has to negate that?
Sure. If this was a case where the officer said, I was standing at the curb and could smell the odor of raw marijuana, and his was the closest house and it's 100
Let's say
feet
you're
away.
standing by the front door and it's found on the back porch in a Tupperware container locked in a safe. I mean, at some point, the bald assertion of having smelled it doesn't carry enough credibility, wouldn't you say? There's a point at which you can't just make a bright line rule anytime the law enforcement officer says, I smell raw marijuana. I mean, obviously we can't do that, can we?
Well, I think what Justice Stiegel here said is probably pretty accurate, that we already have a odor plus standard, and in this particular case, it was the fact that he could smell it from the porch. What I think is kind of confusing is that
Well, I mean, can we look at the after the fact?
we oftentimes play Monday morning quarterback, and that is, well, geez, the officer said that he or she smelled the strong odor of raw marijuana, but we only found X. We don't know what happened prior to the officer arriving. There could have been a whole bunch there, and just for whatever reason that they took it to a stash house, sold it, whatever, transferred it somewhere else, the odor is still there, probable cause is still there. Again, we're dealing with...
And that deals with the lingering problem.
Yeah.
How long does it linger? It's like the dissipation of alcohol in the blood in DUI case. I mean, if we don't have any information about how that works, which
Well,
is
then
what
how-
happens. This is the functional problem here, is that if we just say, once they smell it, we're done. If we say that,
Well,
then we eliminate any need to ever go behind the evidence.
well, but in this particular case, I think that the facts are what's crucial here. The officer is on the front porch. The defendant opens the door. The strong odor of raw marijuana comes out of the residence. We're not talking about the officer smelling it from 30 feet away or trying to figure out.
I thought you
which
just told me you
of
didn't know
parts.
how far inside the house it was.
No, I mean, the officer's 30 feet away from the actual residence. So he can't tell where the odor is coming from or which apartment that is coming from.
Isn't the problem we're having here is just what was pointed out in defendant's argument, is the subjective nature of what we're dealing with, and that is the odor and where it emanates from. And that's different from other sensory exceptions we allow. We allow plain view because what is in view can then be tested in court. And I think the same thing is true with plain feel, is that when you're pat down and we said, yeah, you can feel what's there, that becomes evidence in the case. How does odor become evidence in a case other than what we're talking about now, which is really subjective? How strong is it? What does it emanate from? Is it raw? Is it burnt?
Okay.
I think there's real dangers in allowing this to be the sole reason by which a warrant is issued, or the sole reason in which we enter the privacy of someone's home. And why should I be concerned about that?
Well, one, the defense main premise on this particular thing is that cops are going to lie just to search a house. Okay, that's very dangerous.
No, that's not what anyone's proposing here.
Well, no, because the argument here was, well, because there's no way that the officers could ever be questioned. But we already have
You can't
this odor.
question the basis of the perception
Sure, you can, and that's
without
basically-
accusing them of lying. I don't know what you're talking about.
Okay, well, the way I understood defense counsel's argument was that one of the dangers here was by allowing odor, that this kind of opens up the officer's door to be able to mislead the court.
Well, no, it's just the dangers of allowing the smell of a crime to satisfy, and that's the only evidence that you have to satisfy
Right.
a
But we
search
already
warrant.
allow the odor as a basis to search a vehicle. We already allow canines, properly trained canines, to provide probable cause for searches. I don't see how this is any different, because a drug canine is not going to be able to tell you there's 4 kilograms of cocaine back in the trunk, or there's 30 pounds of marijuana back in the cargo hold. And oftentimes officers will smell strong odors and they won't find anything. That doesn't mean they lack probable cause. That doesn't mean that their noses weren't working properly. It just means the drug is no longer there. But time and time again, our appellate courts have upheld the odors are sufficient. The only difference here is whether or not you need to get a warrant. And here, the officers got a warrant. They did exactly what they were supposed to do. They restrained the only suspect that they had. They applied for a search warrant, and they searched the house. And even if the search warrant was not valid, I think good faith still applies here. You can't take the actions of the officer and go, well, if they wanted to contest what was potentially omitted out of the affidavit, they could have done a Frank's hearing. Said, hey, look, Judge, there's all kinds of facts the magistrate didn't know about. But they didn't do that. They just relied on the Huff case. And in this particular case, I don't particularly see the dangers of saying odor. We smell the odor when you're on the doorstep to a house and you apply for a search warrant, how that's not probable cause. We have already to standard. And so, and again, I think this course is going to open up a whole Pandora's box of what constitutes plus. If officers don't understand this now, you add that plus, and it's going to cause all kinds of problems, not only for judges, but for prosecutors. So I think that standard's already pretty well set. And so.
Do we have any further questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. Now call the fourth case on this morning's docket. Case number 112841, State of Kansas v. Pablo Alberto Gonzalez.
Good morning. May it please the court. Carol Longenecker Schmidt representing Mr. Gonzalez. Mr. Chief Justice, I would like 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Just to offer a very brief factual description, this is an appeal of a jury trial conviction for unintentional but reckless second-degree murder. The conviction stems from an incident that occurred on New Year's Eve 2014 where Mr. Gonzalez accidentally shot his friend. On appeal, Mr. Gonzalez argued several issues. One about the constitutionality of the second-degree murder statute, a sufficiency issue, and some issues about the district court's answering of a jury question. The Court of Appeals found error in how the district court handled the answering of the jury question, but that error was harmless. Mr. Gonzalez filed a petition for review, and that brings us to this point today. This case is all about the difference between unintentional reckless second-degree murder and reckless involuntary manslaughter. Unless your honors direct me otherwise, I'd like to focus on the fourth issue in the brief, the issue that the Court of Appeals found error with, and that error was the denial of Mr. Gonzalez's right to be present at every critical stage of his trial, specifically during the discussion about the jury's written question about the differences between second-degree murder and reckless involuntary manslaughter. There is a pending motion before this court that the state filed, a motion to remand for recreation of the record. Mr. Hodgkinson filed a response, and so we just incorporate those arguments here. But the main argument is that the state had the chance to petition the Court of Appeals finding that there was error and did not do that. So here today, we are assuming there's error and only focusing on harmlessness. The Court of Appeals specifically found that because there's no record about any of the conversations about the question, that we have to assume that it was conducted outside of the presence of Mr. Gonzalez. Mr. Gonzalez argues that this was harmless for 4 reasons, and those are the 4 factors that both of the briefs discuss. First, the first factor when thinking about harmlessness, which is the state's burden, but the first factor is to look at whether there was an objection. Here, there was no objection. However, there's no indication in the record that the defense attorney even knew about the question. The question was not apparently filed in the district court. It somehow made it into the record on appeal, but we don't have any information that would have given the defense attorney knowledge about this question and an opportunity to object. The strength of the case is the second factor. Although there may be sufficient evidence, which we argue there is not, the state's case was not strong in this case. The state's evidence was not strong in this case. The ability of a post-trial motion to fix the problem. Here the question is the ability of a post-trial motion, which necessarily, I guess, asks, did anyone pursue it? But here I don't think that even if counsel had pursued a post-trial motion, that it could have fixed the problem, because our argument is that, in part, is that the answer given to the jury was also incorrect. A post-trial motion in this situation would have been, I think, a motion for a new trial, which is essentially also what we're asking for here. So this is different than a situation where you could file a post-trial motion and bring jurors in and ask, was the question read to you exactly how it was written on the paper? That's an important question in this case, but more important, even if the question or the answer, was read exactly how it was written, we argue that the response was incorrect. So substantively, the answer was incorrect.
Oh, I'm confused. The answer was go look at the instructions.
Yes. So that weaves back to the third issue in the brief, which was that answer was not a meaningful answer. That answer should have.
It's not incorrect. That's what I'm jumping on, I guess. Here is. I mean, as I understood your argument, it is that since the jury has asked a question, they deserve an answer. They already had the instructions in front of them. So that's the way I got it, that it was inadequate because they'd asked a question and you only told them what they already knew. Am I missing something?
Yes.
Okay.
So the answer should have been, or as I read it in the brief, should have been quoting some language from Robinson, essentially. So the jury was presented with 2 possibilities, two different crimes, and they were having trouble distinguishing between the 2. And Robinson provides clarification on what this court has said, at least in the past, is the difference between those 2 offenses. And instead, the district court did not give a meaningful answer, just referred the jury to the instructions, which didn't help them clarify the difference between the 2 offenses.
Okay, so make the argument that if that had happened, the verdict would have been different. 'Cause I see those factors, and I was thinking about this last night. I see those factors. A lot of it really just falls by the wayside. What we need to know is whether this made a difference. And so, given your theory of what should have happened, why does that matter?
This gets a little tricky because it leads back to our first issue, where we argue that there really is no difference between the 2 statutes. And if that's true, then it's actually impossible to explain to the jury the distinction between these 2 crimes. So I think providing the answer articulated in Robinson would have helped the jury get to a different result.
And that result then would have been involuntary manslaughter.
Yes.
Because you're saying the elements of the offense are identical.
That is essentially what we're saying. They are identical.
And that's different than being unconstitutionally vague. That's where I had difficulty with you, because it's not vague just because 2 statutes have the same elements.
I think they are can be taken differently. I think when 2 statutes have the same elements, one of those statutes, in this case, second-degree murder, necessarily has to be vague, because So the legislature has split these out into two different elements: reckless, and then under circumstances manifesting extreme indifference. And as a person of the public, if you're looking at that and you see, well, there's two different elements, they must mean different things, but they're defined as the same thing, that is confusing. I don't know how to gauge my behavior. I don't know how to define that extreme recklessness if there's two elements, but they both mean the same thing. So yes, we are arguing that they are identical, and I don't think it affects the constitutionality of the reckless and voluntary manslaughter statute. But here, because the legislature lists them out as separate elements, but they define the same thing, it makes it unclear. And even if this court finds that it is not so vague as to render the statute unconstitutional, at the very least, the jury needed some clarification about the degree of recklessness that was required to convict under second-degree murder. I think that's particularly important because of the, I think it was 2013, the amendment to the culpable mental states that redefined recklessness. So Robinson was interpreting the statutes under the old definition of recklessness that just required a realization of the imminence of danger. Now, recklessness is defined as being aware that a certain result, death, will follow, and then consciously disregarding that risk. If you are aware that death will follow and you disregard that, you necessarily have an indifference to the value of human life. And so that's the argument that the two statutes actually prohibit the same conduct, or at the very least, it's confusing, as the jury was confused in this case, and the court has an obligation to clarify the degree of recklessness. I'll just briefly touch on Johnson versus U.S. and then wrap up. I think the only point that has not been discussed, that I have not mentioned about why the second-degree murder statute is unconstitutional, is the United States Supreme Court's 2015 holding in Johnson v. U.S. That case is a different context, one about sentencing under a residual federal sentencing statute. But I do think it opens the door for a broader vagueness analysis for this court. I think what Johnson stands for is the proposition that for a person to imagine an ordinary crime, in this case, an ordinary reckless killing, and then to have to imagine a higher level of recklessness, to go beyond that is too vague, that does not...
Explain that to me, because I don't see that as the mechanical process that the instructions are directing the jury to do. I understand it in Johnson, I think, because there's a judge is having to imagine a different crime. The jury is always being told to take the facts as they unfolded at the trial. Those are real facts. That's not an imaginary anything. And to apply those facts to two different descriptions of two different crimes. I mean, I don't want to argue about identical offenses. But the jury is always told to use the facts as they have determined them from the evidence at trial. So they're not imagining anything. But that's the difference I see between what's happening here and what you're talking about in Johnson. So where am I wrong?
The distinction, I think, is that, so here, when we're looking at a vagueness analysis, it can be helpful to look at it through the perspective of a jury reviewing facts at trial. But we're also talking about, generally, does the statute provide sufficient warning for people, or does it invite arbitrary enforcement? And so you can take it out of the context of this trial and think about other applications. And when a person is reviewing their conduct, they're required to imagine an ordinary reckless killing, that the level of recklessness that's ordinarily involved in all killings.
I don't see any imagining happening. that's where I'm jumping off on you on. I don't see where the jury is supposed to figure out some, they're not even trying to figure out what a reasonable person would necessarily do. Here are the facts, put them against this standard and this standard.
And I think my argument is that I'm not talking about the jury and the facts in this case. I'm talking about a person out in the world being aware of whether his or her conduct constitutes second-degree unintentional, right?
The first prong of the two-prong test that's talked about.
Right.
Okay.
You're talking about the notice requirement, basically.
Yes, I am. Yeah, and so that person is not evaluating. I mean, you know, they're in the moment of their actions, but they're not evaluating some sort of other set of facts. They are required in that moment to imagine an ordinary reckless killing, and then does their conduct go to this higher level of recklessness?
And what should any person think when they put a gun to someone's head and pull the trigger?
That is reckless conduct, and that there is a risk that will result in the death of the person you are pointing that gun at.
And that's not manifesting extreme indifference to the value of human life?
Two answers: no, because he previously pointed the gun at his own head, but more importantly, because he immediately drove to the police seeking help. And
that's the unintentional part of it, I think, isn't it? I mean, if you're intending to shoot him, then maybe you let him lie there. But if you didn't intend to shoot him, then you call 911 or you go get
well,
help.
but I
You're
think
horrified by the results of your recklessness.
yeah, but that would show that you do value human life. That's my understanding. I mean, there are examples of depraved heart second-degree murder where you hit a person on the head intentionally and that person's unconscious and then you just walk away. Clearly there you're not valuing that human life. If you know that person's going to die and you don't do anything, you just let it go.
But there are differences there in factual scenarios, and I think whether they're trying to, the New Year's Eve, you run outside with your weapon and you start shooting in the air and someone, versus putting up against someone's head and pulling the trigger. They're both maybe unintentional, but one of them is more egregious, wouldn't you say?
Sure.
And so I think this is intended to, it might be a bit nuanced, but it still sets degrees of crime, and we have that in other areas that degrees are based on culpability. And I agree, most people wouldn't be able to understand most of our legal jumbo, but that doesn't make it unconstitutionally vague just because it's in legal language, but it does set up two different levels of culpability, doesn't it? I mean, you keep saying they're the same thing, but don't you see the factual scenario that's different? And I guess what I need to know is why don't these definitions make that distinction?
Yeah, my answer to that is, again, I'm going to rely on the statutory language and say that the definition of recklessness also describes an extreme indifference to the value of human life. I think there certainly are various factual scenarios that would show various levels of recklessness. Johnson talks about the fact that you can find a statute vague.
You said the definition of recklessness includes extreme indifference.
Not literally, does not include those words.
Right.
But our argument is that if you are aware that your actions will cause death and you do it anyway, that therefore you have an indifference to human life. So the meaning of the words, that means the same thing. In Johnson, the United States Supreme Court said that there are ways, you can find a statute void for vagueness even if some applications it's not void. It doesn't have to be void in all applications, or vague, excuse me, in all applications. Even if this court, I understand that it could be a stretch to find the statute void, but at the very least, the statutory amendment blurs the line and makes it confusing. And here, the district court did not help the jury in distinguishing between those two offenses. Also did not, also violated Mr. Gonzalez's right to be present during the discussion. And the state has the burden here to show beyond a reasonable doubt that that did not contribute to the verdict. And so with that, I would just respectfully request that this court reverse Mr. Gonzalez's conviction.
I have a couple questions, if I can, on an issue that I don't think we've talked about yet, and I'll try to make this quick. And I think it's issue 4, where you say the district court erred by failing to answer the jury question in open court. Your argument there is that that's a Sixth Amendment violation, right?
Yes.
And so if we have a statute that permits the district court to do this in writing, you don't care about that because you're saying it's a constitutional violation, right?
Yes.
And is the specific Sixth Amendment violation you're alleging the failure of a public trial, or is it the failure of the defendant to be present at all critical stages, or is it both?
It is, as briefed, I understand it to be both.
Okay.
That they were, yeah.
So you did preserve and argue that it was a Sixth Amendment violation to fail to answer the jury question in open court because it denied your client his right to be present at that critical stage.
That, I'd have to review that.
Okay.
I'm not sure if it was a violation just to be absent during the discussion about the question, or if
those are
if it was
two
briefed.
issues, at least as I understand it.
Sure.
Is issue 3 is presence during the discussion, and issue 4 is the answering of the question, or
Presence.
failure to answer in open court.
Sure.
Presence when the written answer was just given to the jury.
I do not recall if presence during the answer, if that was briefed and preserved, or if it was just, if that part, the answer was just argued as a violation of the
Okay.
right to a public trial. I can review the brief and
Okay,
try
thank
to
you.
submit a helpful answer.
Any more questions? Thank you, counsel.
Good afternoon. May it please the court, the appellee, State of Kansas, appears by Stephen Uppermeyer. I'm a assistant solicitor general.
You just couldn't stay away from us, could you?
I could not. I was at home watching Rockford Files, and my wife gave me a 2-prong test. Find a hobby that gets you out of the house. And so here I am. And I'll argue issues 1, 3, and 4 in that order. As to issue 1, does the statute sufficiently give a warning to the defendant that when you point a gun at somebody's neck, when you're 3 times the legal limit, 0.25 BAC, 3 hours later, not sure whether the gun is loaded and you pull the trigger, whether you don't understand that might manifest extreme indifference to the value of human life by your conduct? Do I not understand, how can you not understand that?
But I don't think that's, well, maybe that is the argument, but I thought the argument was, how would you not also understand that was conduct done under circumstances that show a realization of the imminence of danger to the person of another and a conscious and unjustifiable disregard of that danger. And I think it's where you split that hair between those two, and how you distinguish the legalese of extreme indifference to the value of human life and a conscious and unjustified disregard of the danger to the person of another.
I think you split it by, as the court did in State versus Cordray and State versus Robinson, by saying if your conduct is reckless, that's involuntary manslaughter by disregard, substantial and unjustifiable risk that deviates from the standard of care, gross deviation from the standard of care. But on top of that, if that recklessness is under circumstances manifesting extreme indifference to human life, then that elevates it from the involuntary manslaughter to the reckless second-degree homicide. And I think that's what the court has said in Cordray and Robinson. I think the U.S. versus
That's an argument of how we split the hair, but I think the argument, how does ordinary citizens split that hair and know, which conduct is prohibited in what manner? Or is it enough to know it's prohibited conduct and the degree will fall where it falls?
I think it's probably just the latter, that what you do there is showing extreme indifference to human life.
The notice prong of the vagueness analysis is really just a legal fiction, isn't it? Because people don't walk around saying, I might do that if it's only involuntary manslaughter, but if it's intentional second degree, I'm not going there. I mean, that's just not the way we operate, right? We just live and we do good things and bad things, and then later on, all of us figure out how to classify it and what to charge and what to prosecute and what you get convicted of. It's a theory. If a reasonable, ordinary person looked at it and was aware of it, then could they tell the difference? It's not whether they walk around knowing the difference, is it?
Correct. I doubt that Mr. Gonzalez researched the difference before he...
Most people who commit these crimes do not spend a lot of time splitting the hair, my colleagues identified. Right. Not in advance. So warning is a fiction, a legal fiction we engage in to make sure that the statute's not vague.
Well, as I understand it, that there has to be sufficient warning that by doing this, that it makes it vague. And the second part is that it guards against arbitrary enforcement, and we have the presumption that it's constitutional. So
that's okay. I think I already.
Okay. All right. There's some language in the Johnson case that the Court of Appeals cited, distinguishing Johnson from this case. In Johnson, the court said at page 2557 that the residual clause language ties the judicial assessment of risk to a judicially imagined ordinary case of a crime, not to real-world facts or statutory elements. And here we have statutory elements that make it a difference, and that is the under circumstances manifesting extreme indifference. Which leads us to the third issue, whether Judge Elder's answer was an abuse of discretion in not helping the jury answer the question. And the state's contention is that it was a legally correct answer to the question, can you provide more clarification of the differences between murder in the second degree committed unintentionally and the involuntary manslaughter? So it sounds like they have clarification. They're just asking for more clarification, or at least one juror is asking for more clarification. I mean, sometimes I think we think it's a 12-0 vote on what makes a jury question, and I don't think that's always the case. So we have the district court judge who can look at State versus Robinson or Cordray, which has language saying a jury is expected to decipher many difficult phrases without receiving specific definitions such as the term reasonable doubt. That's from Robinson. And Cordray, where the same question by the jury, and the judge referred the jury back to the instructions. And keep in mind that the judges don't have, this jury trial was in August of 2014. They don't have 3 years and a few months to decide how we're going to answer this question. They've got a jury over there waiting. And so the judge answered, please refer to the instructions provided to you. And in the appellant's brief, they came up with a proposed answer 12 months after the fact, and when their brief was filed, which basically is a repetition of the jury instructions 10 and 11. It's just a restatement of jury instructions 10 and 11. And so I think it was an adequate answer by the judge, and a reasonable person would take the position adopted by the district court in doing that. Which brings us to this next issue, the improper conducting of discussions about the jury's question off the records and outside the presence of Mr. Gonzalez. And to get to this question, we make a lot of assumptions that that number one, that the judge isn't familiar with what the law is, that you bring in the defendant and the attorney when you have a question. We don't assume that the defendant's present, whether there's a discussion with counsel, whether it was held outside the public's purview. We're making all these assumptions and kind of making it a negative assessment to the judge, that the judge doesn't know what he's doing. That he just went rogue and just answered this question on his own and didn't let anybody know. And so that's one of the reasons that I asked that if you do consider some sort of reversibility inquiry like you did in the Horton case, I think it was, that let's at least have some sort of hearing on what actually happened. And you can tell by the transcript that the judge was aware that had talked with counsel during the course of the trial. In chambers, at page 352, there had been an in-chambers conversation that the defendant's witness wasn't going to be here till 1:30 in the afternoon. And so they continued it till the afternoon.
Well, in Horton, we didn't remand it back to clarify what happened. In Horton, what occurred, as I recall, was that there was a motion brought by defense counsel after the jury began its deliberations, and Judge Davis said, boy, I wish I could consider that, but once deliberations start, I can't do anything. And then on appeal, we determined that that was an abuse of discretion. Yes, we have case law that allows you to, in limited circumstances, to reopen the case. We sent it back for Judge Davis to consider, and I recall it was a transcript that was from a strange dialect from a South American country or something, so it took some time to get what that was. But the point was that we found that there was an abuse of discretion. Go back and reevaluate it once you get that evidence as to whether you had allowed the jury to hear this evidence. That's different than what you're asking for. You're asking us to kind of recreate what happened, and I think there's a real difference here.
Well, you didn't.
It would be pretty rare that we would take the road. It was pretty rare we took the road there, but it's
right.
Anytime there's an absence in the record, we would just send it back to recreate what happened. I mean,
well,
that's different. That's different. There's not an absence in the record.
Right, and usually there's a presumption that the judge acted correctly and knew what the law was, but we don't seem to be doing that. But you're correct as to your recitation as far as Horton, that I don't think there was the transcripts presented to the judge for the reversibility inquiry. I was just saying, and looking through the record, that the judge knew that you have these conferences with defense counsel. For example, at page 397, volume 7, the judge, it's a close of trial on Wednesday, close of evidence, and the judge says, I can email jury instructions to you. I've got the verdict forms, so we can go back to my chambers and we can go through some of that, okay? And the prosecutor says, and you want to do that now, Judge? And the death penalty defender attorney, Mr. Gonzalez's attorney, says, I don't require Pablo's presence. Fine, you remain in custody. So the judge knows that there's this rule about having the defendant present for things like discussing jury instructions. And there's several references, like in Volume 7, page 396, of discussing things in chambers. Same thing in Volume 8 at 404 at the jury instruction conference. There'd been an informal conference about jury instructions, and then on the record, the defense attorney explains why he thinks there should be a voluntary instruction, or voluntary intoxication instruction. So that attorney knows how to make a record by objecting to things. And so here we have the question, can you give us more clarification on that? If there's no disagreement that you should refer back to the instructions, I guess there would not be a record on that. But
let me ask you about what happened next,
okay.
which is the answer.
Yes.
Are you contending that the defendant was present when the answer was given to the jury?
The record isn't, well, if it were remanded, I think it would be something that would, it sure make a difference.
The record doesn't say.
The record doesn't say.
At first blush, we would presume that he wasn't present, but that's also a different procedural stage, and I'm just wondering if you would make the same kinds of arguments, like typical process would have been for the defendant to be present. Would it? I mean, are you saying that typically when the judge sends a written response back, he would have called everyone into open court and had the defendant present to do that?
I think it probably varies with the judge, and I don't know.
Well, presume with me that the defendant was not present.
Okay.
When that answer was given to the jury.
Okay.
Why isn't that constitutional error?
Well, if he's not present and that's a critical stage, and defense counsel can't waive his presence like he did waiving the defendant's presence on the last day of evidence, it would be...
Well, we have a case, we have precedent, State v. King, 2013 case,
right,
where we held that a court answering a question to a jury by written response violates the Sixth Amendment if it's not done in open court with the defendant present. That's what State v. King says. We have a statute that says the judge can send the answer back in writing. I'm exploring the potential tension between those things.
Okay.
Do you have a position on that?
My position is that there's no claim that the statute's unconstitutional. I'm not sure there's a U.S. Supreme Court case that says that it's a critical stage of the proceedings for the defendant to be present during a legal question or a question that the jury has. And in my 609 letter, I cited a sublet case out of the state of Washington, kind of talking about whether that's an issue. But here the statute says the judge shall respond to all questions in writing or in open court. And so in writing would be appropriate. And since that answer is filed and somehow it got into the record on appeal here, that would not violate the Sixth Amendment right, I think would be my answer.
We were just wrong
question.
when we said that it did in State v. King. That's your position.
Well, I don't like to say that.
Well,
certainly, I think the primary issue in King was it violated the statute, which had been amended in 2014 and was in effect at the time of this trial in August of 2014. So I think that's what I would respond. And if it is a Sixth Amendment right, then you get to the whether or not it's harmless error, and for the reasons set forth in the Coyote type of line of cases, it was an innocuous answer referring the jury back to the jury instructions, and that there was not a reversible error in that answer given. State versus Reed, and I'm not sure when Reed came out in the context of King, probably after, says the public trial right attaches to those hearings whose subject matter involves the values
Right, but that gets to the question I was asking your opposing counsel, and I don't need to belabor it, but there's a difference between a public trial right and a right to be present. And the outcome might be different depending on which right we're talking about.
Correct. And here again, we don't have a record that knows what right we're talking about. I mean, back when I was a trial attorney, some of these things would be done in chambers, and if the press wanted to be back there, they could. Some of them were done in open court, and so I think that's a little bit different issue. But I think just the issue, we're just going to presume from a silent record. I cited State versus Jones, or State versus Jones is mentioned in the brief. And that was a case where the court reporter did not put in there that the defendant was present on that issue. And the defendant was present. And it got reversed for that, for a new trial, because the judge's answer was incorrect. And I just think that's something more to consider on a 1507 after the fact, instead of we're going to just go from a silent record, draw inferences against the trial judge, and presume the defendant wasn't there, and just presume error. But I know that Betts is against me on that issue, and the law seems to be. But even with what the judge did with that process, that it was as harmless error if you get to that issue. I think that's all that I had as far as my presentation.
Do we have any further questions? Thank you, counsel.
Thank you.
Just briefly, in regard to Justice Stiegel's question about the constitutional right to be present and what has been preserved. I think in the brief, both presence during deliberations or discussions about the question and during the delivery or reading of the question, I think both of those aspects, right to be present, were briefed. As well as public trial, both of those are a public trial. However, the Court of Appeals only focused on absence during the discussion about the answer, and the petition for review only discusses harmlessness. So I'm not sure if this is properly preserved to talk about, let's see, the defendant's constitutional right to be present during the readback, or the tension between the constitutional right and the statute allowing a written answer.
Any further presentation?
No, Your Honor, I would waive the remainder of my rebuttal.
Well, let me ask a question. You've got your brief in front of you. Page 13 is the proposed answer that you have that on page 13 of your brief.
Oh, yeah. Okay.
Go get it.
You can go get it if you want.
I got it here. Okay, yes, Your Honor.
As I look through that, the only thing that I see different from what's in the instructions already is the second sentence. Would you agree with me that the second, I'm not sure that it's legally accurate, but I don't want to quibble about that right now. Regardless, the second sentence is really just a transition to tell the jury to look at the next two sentences, right? I'm asking, you're saying that there wasn't a meaningful answer, and I'm trying to figure out what's meaningful in what you've proposed.
In this paragraph.
And everything else is in the instructions. But I see the second sentence, which is the one difference, as being introductory, if you will. Because then you're saying, you're looking at different levels of recklessness. The first thing you got to look at is the extreme, and the circumstances that don't value human life, and then you've got the other one. But so do I read the second sentence correctly, do you think? Or is there something substantive in it?
I think that's correct. I think it is a transition sentence. I think the most significant sentence in this paragraph is the third sentence that acknowledges that all reckless killings have some sort of extreme or indifference to the value of human life. And the way you distinguish, arguably under Robinson, is does this killing have an extreme indifference that goes above and beyond that which is inherent in all reckless killings? I think that is still confusing. I don't think that that is, I think that shows why the statute is void, vague for void for vagueness, excuse me. But under this court's current case law in Robinson, I think that was the correct answer. That would have helped the jury determine between the two
And
offenses.
my only thing is, I think that's just instruction 11, subparagraph 1. And so, I'm just having difficulty seeing how this helps a jury that's asked a question versus go back and look at the instructions.
Sure. I think another response is that, this court could conclude that perhaps this proposed instruction would not have helped, but maybe there was maybe there is a current better articulation between the two differences, between these two offenses, particularly now that the statute's been amended. And whatever that is, that clarification should have been given to the jury. And so perhaps remand is appropriate to give a new, more clear, more definite description between the two offenses.
Any more questions? I see none. Thank you, counsel. Thank you both for your arguments this morning and this afternoon. Clerk will take this matter under advisement. That concludes today's docket. Court is now in recess until 9 o'clock tomorrow morning.